listening to CMDA Matters, the weekly podcast of Christian Medical and Dental Associations. Here's your host, Dr. Mike Chupp.
About 4 weeks ago, I had the unique privilege to be in our nation's capital, Washington, D.C., and inside the U.S. Supreme Court for our oral argument in the U.S. Food and Drug Administration versus Alliance for Hippocratic Medicine court case. This case is actually the first time that CMDA has been a named party in a U.S. Supreme Court case, which is a monumental step in our ongoing and growing advocacy work. And on this week's episode of CMDA Matters, Dr. Jeff Barrows and I are joined for an interview with our attorney, Erik Baptist. He's a senior counsel for Alliance Defending Freedom, and you're going to hear us call them ADF during the interview. ADF represents CMDA and the other members of the Alliance for Hippocratic Medicine in this case. So we asked Erik if he would join us for this episode to talk about the overall focus of this case, CMDA's experience at the U.S. Supreme Court, and what this case means for the future of protecting women's health, as well as protecting the conscience freedoms of Christians in healthcare like you and me. Well, today on CMDA Matters, I am joined by Senior Vice President Dr. Jeff Barrows, who's an OBGYN, and that's very important. I was so delighted, Jeff, when you said yes to this position, because I just had a feeling that moving forward, that OBGYN was going to be a specialty of importance for advocacy.
Little did we know what would happen in the interim since I've started in 2020.
And little did we know that you and I were going to be sitting in the Supreme Court of the United States not long ago, hearing arguments made by our attorneys from this wonderful organization, Alliance Defending Freedom.
Absolutely. What an honor that was.
Well, today our guest on CMDA Matters is Mr. Erik Baptist. He serves as senior counsel at Alliance Defending Freedom, and he focuses on administrative litigation and regulatory advocacy. And Erik, medicine is somehow close to your family. Your dad's a physician, I guess.
He is. He's both a professor and a physician. He recently retired as a practicing pediatrician. He still sometimes helps out on that side, but he still teaches the next generation of doctors and med students back home in Illinois.
Well, you were there in the Supreme Court, March 26th, for the oral arguments on Alliance for Hippocratic Medicine versus the FDA in a case involving the abortion drug Mifeprex. And how many times have you been in the Supreme Court arguing a case or with the team?
This is the first time I've actually had a case before the Supreme Court. So it was a great opportunity for me personally and professionally. I've had a lot of cases we've tried to get in front of the Supreme Court and failed to do so because the court only takes a fraction of a percentage of cases every year.
Well, you have an impressive bio, and we'll have that in our show notes today. But I want to save all of our time here today to discuss this case, which you've been helping CMDA and the other organizations within the Alliance for Hippocratic Medicine now for a couple of years. So many of our members, Erik, have a general idea of what this lawsuit, FDA v. Alliance for Hippocratic Medicine, entails. But I think even me, as we went along the way and went to Washington, D.C., maybe unaware of specifically what's at stake in that case before the Supreme Court. So could you start us off by briefly outlining the victories that we had leading up to the Supreme Court case, and what was the exact decision that the Supreme Court had agreed to address in this case?
Yeah, I think going back in time when we filed our lawsuit, what did we challenge against the FDA? And then where did we win along the way? It's very helpful to understand. And I have to always sometimes plead ignorance when it comes to this issue, because before I came to ADF 2 years ago, I didn't know anything about mifepristone, chemical abortion, and the prevalence of it. So very much what does this case mean is it increased tremendously in my personal life and obviously my professional life. And I hope to educate some of your folks as well, because I didn't realize how important this case was until I started working on it and realizing that it is vital for protecting women's health and of course, unborn life. And so when we challenged the FDA over mifepristone, or Mifeprex as the brand name is known, we challenged the approval from the year 2000, the last year of the Clinton administration. And then we went in 2016, challenged a 2016 decision by the Obama FDA to remove many of the initial safeguards that the Clinton FDA had imposed on this drug because it was inherently dangerous, and the FDA at the time recognized that. And finally, we recognized in 2021, the first year of the Biden FDA and the Biden administration, what it did to remove one of the last remaining safeguards, which effectively authorized mail order chemical abortion. And we just heard from the abortion industry, according to their numbers, over 60% of all abortions now are committed by chemical means. So, when you think of the brick and mortar Planned Parenthoods, you think someone's going in there to have a surgical abortion most of the time. That's actually not the case anymore. Since the 2016 changes, the number of chemical abortions have increased exponentially from under 50%, like maybe 33%, 34%, now over 60%, and where they're having no medical intervention, no medical supervision, where women are taking these drugs, never meeting with a doctor to actually take them and have them supervised during this dangerous regimen, which is a 2-drug regimen, mifepristone and then misoprostol, to expel the unborn baby after taking the first drug. And so we challenged that in the district court. We said from the 2000 approval beyond, it was all unlawful. And I think it's important to understand this too, because some people, when we file this lawsuit, it's like, you're just making a policy statement. You're just trying to, you're just arguing about policy, and it's not really a true lawsuit. We're like, no. The FDA, when it received its authority to be the nation's drug gatekeeper from Congress, received specific instructions of how to approve and regulate drugs. And here the FDA, in various forms, violated the law. It violated those instructions. So we had a legal basis to bring our lawsuit. That's always important to know, because it's not just we disagree or we're just pro-life doctors, bringing this case. It's actually because the FDA has to have some rules to live by, and that's how it got its authority in the first place. So we sued over that. And because one thing in the 2000 approval that we like to highlight is the FDA had to call pregnancy an illness to justify its approval under its accelerated approval pathway. I think we can all agree that pregnancy is not an illness. In fact, it's the opposite. It's a blessing. But that is how the FDA had to characterize it from day one to get this drug into the marketplace. And you can just expect that the unlawful activities perpetuated and continued throughout the entire lifespan of this drug. So in the district court, we filed in November of 2022. We moved for what we call a motion for preliminary injunction. So what that means is during the pendency of this case, we wanted immediate relief, because every day this drug remained on the marketplace, or when these safeguards had been removed, women are going to be harmed by it. And what we did was we filed that the same day we filed our complaint. On March 15th, 2023, we had a hearing in front of the district court down in Amarillo, Texas. And then on April 7th, we won on all of our claims, whether it's the 2000 approval or the subsequent actions by the Biden FDA and then the Obama FDA to remove those safeguards. That initiated two different prongs, two different trees, branches, if you will, of litigation after that, because we won on everything. And then the federal government went on an emergency appeal along with Danco Laboratories, which is the brand name manufacturer of mifepristone. They sought immediate appeal and relief to prevent the district court's order from going into effect. They also filed a separate notice of appeal on the merits of their challenge or appeal, but there were two different tracks. And so last year in April, there was a lot of action going on. People may remember this made a lot of the news, and that was on the emergency expedited petition all the way up to the Supreme Court. And the Supreme Court, I like to say we were winning too much too quickly, and the Supreme Court put the pause button on our victories and then said, well, we'll wait till this comes back in the normal course of us before you can do something that would be what the other side is called disruptive, because if you take the drug off the marketplace, or if you bring back those safeguards that were rolled back by the FDA, that could cause disruption to the drug manufacturer and to the abortion providers. The Supreme Court didn't say that, but that's how we kind of read the tea leaves, or at least how I did at least. And then on the merits appeal, we went to the Fifth Circuit Court of Appeals in May of last year when we had an oral argument there. August 16th, the Fifth Circuit Court of Appeals issued its decision. What it said was we were time barred from challenging the 2000 approval. It said, well, there's a normal 6-year statute of limitations. There are some exceptions to that. You didn't meet those exceptions, even though the district court found that you hadn't met those exceptions. So you can't challenge the 2000 approval. So the drug will remain in the marketplace. But you are absolutely correct on the law when it comes to the 2016 and 2021 changes. And again, all this means is, what does this mean? Because I think this may be your next question, is what does it mean for this lawsuit to just have those safeguards come back? It means a woman needs to see a doctor before taking these drugs. That essentially ends the life of the baby and induces labor and delivery up to 10 weeks of gestation. It brings back in-person doctor visits. Right now, you don't ever have to have an in-person office visit with any medical professional under the FDA's regulatory scheme. But in the initial approval pathway until 2016, A woman got to see a doctor before taking these drugs, while she was taking drugs, and then afterwards to ensure she was taking them correctly at the right gestational age. She had no ectopic pregnancy. And at the tail end, to make sure she had no life-threatening complications such as severe infection or heavy bleeding that would require transfusions, among other complications. And so what we're just saying is women deserve better health options here. And to the degree the abortion industry disregards those health options and care, in addition to the FDA's disregard and callous disregard, I would say, to women's health, we were just asking for that back. But the FDA and Danco Laboratories weren't happy with that. So they went back to the Supreme Court and said, you need to hear this case. And the Supreme Court agreed to hear that part of the appeal or that part of our case. So what was at issue last month in front of the Supreme Court was the 2016 and 2021 regulatory actions to take away those basic common sense safeguards for women, not the 2000 approval. So whatever happens in the Supreme Court in the next few months, nothing will take this drug off the marketplace because the Supreme Court did not take up that issue from the Fifth Circuit Court of Appeals. And so that's kind of a high level where we are today.
Thank you.
I'm happy to answer more what that actually means down the road too.
Well, before we get into more of the details of the case, Erik, I know, and you've already mentioned this, that you've been with ADF for about 2 years, but before coming to ADF, you served as a senior appointee at the Environmental Protection Agency, directing EPA's litigation. So I know that played an important part in preparing you for this particular case. So can you elaborate on how that did work out in getting you ready to take on the FDA?
Sure. In a prior life, before coming to ADF, I was an environmental and energy lawyer. And so I was most recently a partner at a law firm in Washington, D.C. Before that, I was in the prior administration as a senior appointee. And even before then, I was also kind of working and challenging the EPA in particular on a lot of its stuff. And my title I talk about like regulatory advocacy and administrative litigation. We try to convince the agencies to do the right thing, and that's what we call regulatory advocacy. And when the agencies don't, we go and do administrative litigation. And so a lot of the cases I worked on back in the day was under the Clean Air Act to deal with biofuels and EPA's kind of esoteric mandates. And many parts of my career, I was like, well, this is interesting. It's important. It deals with energy security and all that. But I didn't see the whole big picture, if you will, or how God's plan designed it. And then when it came to coming to ADF and challenging the FDA, a lot of the cases that I was working on and the issues that I was working on developed a very deep body of case law in what we call the administrative law field that actually helped inform and be used in our case here against the FDA, because administrative law, the principles apply no matter what agency you're challenging. And in this instance, the EPA gets sued a lot by many different factions because the EPA tends to violate the law a lot, or at least people think they do. And there's a body of case law out there. And so we use those cases to support our challenge to the 2000 approval, because there's something called the reopener doctrine. Yes, there's a 6-year statute of limitations to challenge an agency action, but the agency reopens that initial decision. What we argued was they reopened their approval decision by taking away those common sense safeguards. That helped us bring this case. Otherwise, we would never have brought the 2000 approval challenge because we didn't have an option within the 6-year statute of limitations. But because of my experience in the environmental field and both challenging EPA and also representing EPA while I was there, I was well aware of this case law that we could take advantage of and use in our lawsuit.
Well, Erik, one of my favorite memories from March 25th and 26th when we were in D.C. was being at your office there in D.C. and getting to see you there, being greeted by Kristen Wagner, your CEO, and then the incredible experience of being in your office. I've always appreciated ADF as a Christian organization, but on the eve of the case in the Supreme Court, sitting in their audience and having a praise and worship time in which we were singing hymns. It reminded me of Old Testament children of Israel going into battle and the choir leading the way. That was very special. I'll never forget that. But it was in that setting that evening, Erik, in which you came up to me and said, Mike, I am so grateful for CMDA because, frankly, your members were critical for the launch of us getting involved in that case. Could you tell our listeners why you told me that fact that evening?
Sure. And I didn't mention at the beginning, we represent 4 individual doctors and 4 national medical associations, including CMDA. And CMDA has been so vital in this, and without revealing client confidences here in this forum, because to show why we can sue. to show why this is important, we needed to submit declarations of doctors who have witnessed the harms that FDA has inflicted upon women across this country. And CMDA was so instrumental. I still remember 2 years ago trying to pull this case together, working with Dr. Barrows and trying to get that information. And he was great at identifying the key doctors that we needed to tell the story to help win this case and set the framework for why this is important, why doctors are harmed by what FDA did, why their patients are harmed. And without it, we would have had a much weaker case. I wouldn't say we wouldn't be able to do it, but we've only come to where we are today because of CMDA.
Well, Erik, I know that I was a little bit confused, and many of our members who have listened to the audio recordings of the Supreme Court hearing heard that much of the questioning and the arguing surrounded the issue of standing for the AHM, and with really very few exceptions, didn't delve much into the merits of the case, what I would call the merits, what the FDA did wrong, specifically their failure to follow the APA. And so I and several of our members have been surprised by that. So could you elaborate on why the justices asked so many questions on standing, as well as the issue of conscience harm, conscience freedoms, rather than about the FDA itself?
Well, I'll start with this. Based on my experience, again, before coming to ADF, like every case almost you file against the government, they're going to argue standing. And in particular, the government likes to argue standing when it has no defense of the merits of its actions. So I'll get into what that means a little later, but I think the government spent, if you look at their briefs when they filed in the court, 75 to 80% of their brief was focused on standing. So it's not a surprise that the Supreme Court would focus on standing too, because there's not much to defend of what FDA did. But standing is important. It's a constitutional requirement under Article 3 of our U.S. Constitution. It says that you have to have a case or controversy. And to have a case or controversy means that a court just doesn't issue an opinion or what they call an advisory opinion. It actually has to have a case and a controversy to resolve. And if you're not actually injured by that federal agency action here, the FDA's action, you're not the right person to bring this lawsuit. And so that's why they want to make sure that our clients were the right people to bring this lawsuit. Even if the FDA willfully and openly violated the law, are we the right plaintiff to bring so? And because once we get through that gatekeeping function, we win. And I think almost everybody recognizes that, who's an honest broker in reviewing what the FDA has done, what they said they did to justify these actions. So really, that's why it was, in my mind, if we win standing, we win everything. And that's why you've seen at the district court, everybody always addresses standing first. It's a threshold question. The opinions, even where we won, they address standing, and then the merits kind of feed itself. And so it was not a complete surprise that most of the argument was going to be focused on standing. It's a requirement under the Constitution, as I mentioned. And so we had about 4 different arguments for standing. So one would be conscience, one would be emotional, the third would be kind of a diversion of time and resources or redirecting your practice. And the fourth is something called organizational standing. And I can unpack that. We led with conscience standing, and we spent most of our standing sections in our briefs on conscience. So that's why the Supreme Court in particular focused on the conscience angle of what FDA did and how did it affect our doctors in the emergency room or in hospitals, and how did it affect their conscience. And so that's kind of why the court was focused on it, and why they focused on particularly the conscience issue.
Before we continue with this week's episode, here's a special announcement for you. As a result of a partnership between CMDA and Alliance Defending Freedom, we are now offering free legal consultations for CMDA members who may be experiencing conscience freedom issues in the workplace. Exclusively available to CMDA members, this program is designed to serve members who feel they are being discriminated against in the workplace due to their firmly held moral and religious beliefs. If you feel your conscience freedoms are at risk, please visit cmda.org/legal to learn more about how we can help. Have you heard about freedomtocare.org? It is the hub for CMDA's advocacy work. There you will find resources, ways to get involved, information about active federal bills that we are tracking, and much more. Freedom to Care is focused on educating, encouraging, and equipping citizens to advocate our First Amendment freedoms. Plus, we enable healthcare professionals to uphold life-honoring principles found within traditional Hippocratic medical ethics. For more information, visit freedomtocare.org. That's freedom, the number 2, care.org. Let's jump right back into this week's episode.
So, Erik, we anticipate that, like Dobbs, sometime toward the end of June, maybe 1st of July, the Supreme Court will hand down a decision on this case. So could you just briefly lay out what are the possible decisions that this court might make in relationship to access to mifepristone?
What we asked, and this is obviously our hope and prayer, is that they agree with what the Fifth Circuit did. They affirm the Fifth Circuit's decision. They find that we have standing. They affirm that the FDA willfully and recklessly violated the laws that govern it. And therefore, it would restore the protections that exceeded before the changes that were made in 2016 and then later in 2021. So effectively, you won't have pharmacies handing out these drugs, at your local Walgreens or CVS. You won't have them being mailed across the country without any medical intervention or office visit. You're going to have women's health being protected once again to a better degree. I wouldn't say a full degree, but at least they will have those common sense safeguards of 3 office visits, meeting with the doctor, understanding what she's about to go through. A lot of the times you read these stories, whether it's even the Washington Post and New York Times, they'll write about this, and where women did not expect to undergo what they went through the pain, suffering, bleeding, and also seeing their unborn baby in their own hands and what to do with it in that situation. And because they weren't properly counseled, they weren't properly treated by medical professionals throughout that. So that's what it would mean. In a lesser scenario, there are other multiple options. The court could agree that, again, we have standing, but maybe they didn't agree with the arguments on the 2016 changes. But what the Biden and FDA did in 2021 was so egregious, where if you have no medical intervention, no meeting with the doctor before taking these drugs, and you just can mail them willy-nilly across this country, that is patently unlawful, which we also agree is completely unlawful. They may kind of split the decision that way. The other way, I think, is going to be what I would call like a temporary setback would be, well, you didn't sufficiently prove standing in this case. Your conscious harm, they focus on that. Well, did your declarations match the conscious harm exactly? We don't know. If this is too speculative in nature, that's some of the questions we're asking. And so we didn't prove standing, go back to the district court. And I would argue do it all over again, or do it better, or you're going to get dismissed out of the case. So, or you'll have to do something different at least.
Well, as the lead counsel at ADF on this case, no doubt you spent a lot of time studying the FDA's actions surrounding the drug mifepristone. And you've talked about the various stages of the approval process in 2000 and changes in 2016 and 2021. But through all of that, what stands out in your mind as the most egregious action that the FDA undertook? And what 1 or 2 things would you want our members as healthcare professionals to be aware of most about the approval and use of this drug?
I'm going to ask for not 1, but 3, because there's just so much that FDA did. I'm cheating here. I'm sorry, but I
That's fine.
have to give that answer.
That's fine.
So this is unlike any other. So going back to the approval, like in the 1990s, it was like day 2 of the Clinton administration, where President Bill Clinton, back in 1993, directed his cabinet to bring mifepristone to the United States. It was known. I'm old enough to remember. It was known as RU-486. It was coming from France, and he directed them. And they had to strong-arm the French manufacturer to sell the U.S. patent rights to a different company. It was sold to the Population Council. I don't have to tell you much about the Population Council. Just knowing by the name itself and its founders, you would know that it's not necessarily a health organization dedicated to promoting life. But this is unlike any. And then they coerced them to, essentially submit a new drug application. Nowhere in the history of, the FDA where you see that the government trying to help negotiate intellectual property rights to bring a drug to this country, and then to get it approved. Usually a drug manufacturer is asking the FDA to do this. This is the first time the FDA is trying to really manipulate and bring this drug in the country. So I only bring that up to set the framework of how this drug has been regulated and approved since the beginning. It's always been political. It's always put science as second place, if that even. And then I've already talked about calling pregnancy an illness. That to me is just egregious, offensive, and everything under the sun. And they have not really well defended that. They're like, well, we said, an illness, but we didn't really mean illness. Like, the words matter. You have that in your regulation. You have to live by that. But I'm going to fast forward 21 years from the 2000 approval to what the Biden FDA did. Because here's what they did. When they authorized mail order abortions, where they said women never has to meet with a medical professional before taking these high-risk drugs, it had to justify. And under the statutory standard, again, this is why we brought the lawsuit, because the statute sets the standard by which the federal agency, here the FDA, must comply. It said you need to have adequate tests to show safety. What did the FDA say when it actually made this decision? Our studies are not adequate to show safety. I laugh only in the sense that it is so blatantly unlawful. You don't need to be a doctor. You don't need to be a scientist. You can be a lawyer like me to understand that this cannot stand. It's what we call arbitrary and capricious and not in accordance with law under the statutory standard. And that's why, again, the Supreme Court, in my mind, never had to ask the FDA about this unless they just want to make the Solicitor General uncomfortable to defend the agency's action. But it was so egregiously unlawful. It doesn't take a rocket scientist or an engineer or a doctor to figure that out. And so I point that out because when you hear the other side say, well, this is a safe and effective drug, it's safer than Tylenol or Advil, and it's been rigorously studied by the FDA, we just point to the FDA's own words. And the FDA has said that the studies that supported this change were not adequate to show safety. Game, set, match in my world. Just one other point about Tylenol, Advil. This is a drug that sends, according to the FDA's own label, at least or roughly 1 in 25 women to the emergency room. You don't get that warning on Advil or Tylenol. It doesn't send 1 in 25 people to the emergency room as used as directed. So again, that's another lie that the FDA has perpetuated, and we need to make sure we combat that with the truth.
Erik, I want to ask Dr. Barrows a question because we've had many different discussions over the last several months about this whole issue. I'm not an OBGYN, but he practiced for many years. And you told me, Jeff, that many studies have shown that when women came into your office and they were remembering their last menstrual period and how far along they were in pregnancy, that a very large percentage are off base in some respect. Can you just remind me of what you shared with me?
Well, actually, if you look on the ACOG website, American College of OBGYN, they cite a study where, and this was done back in the 80s, I believe, but about 40% of the time, when they took the last menstrual period and then they did an ultrasound to verify the dates, the 40% of the time the women were wrong. That's an astounding number. And so typically, if they're wrong, they're actually further along than what they said.
That's what I was assuming, that they would be wrong so that the pregnancy is further along.
Exactly.
So therefore, since all of these regulations have to do with a cutoff in terms of when mifepristone is relatively safer than later periods of time, clearly without a visit and just information over a telemedicine visit, there's going to be a lot of errors.
There's no doubt in my mind or any of the OBGYNs I'm talking with that there are women that are 11, 12, 13, 14 weeks along taking the medication thinking they're a month sooner. They're right at the edge of when it's supposedly, quote, safe to be used. But no doubt that they're much further along, many of them.
And the motto, Erik, for ADF, as we were there, women's health matters. The other side is going to throw darts at CMDA and APLOG and the others, Catholic Medical Association, that we're just trying to take out mifepristone. But the reality is this is about women's health.
Exactly. It is. It is. And I was going to say, Erik, as I read through, and I've been reading about this case since it started back in 2022. When I started learning about the whole process, and you've talked about the population council and what happened, I was absolutely astounded. I mean, I just thought, how in the world did the FDA get away with this? And then to go on in 2016 and 2021, it's just from a pure women's safety perspective, it's astounding what's going on. So as we get close to finishing up, I know that you've mentioned, in fact, you just mentioned about the possibility, hopefully that's not the case, of returning to the federal district court. But as our members continue to see these patients that are dealing with complications from mifepristone, what can they do? Is there anything they can do in assisting your efforts in furthering this case down the road if it happens to return to the district court?
Two things you can do, and I always start off with this: pray. Prayer is the most powerful weapon on our side, and continue to pray for the wisdom of the justices, the courage, make sure they can discern what our arguments and understand where we're coming from, and that truth and justice prevail ultimately. So on a daily basis, we continue to pray. It's not over yet in terms of like they have made their decision in theory and now they're writing the opinions, but prayer works, and I continue to ask for those prayers along with the safety and protection of the justices. We saw what happened after Dobbs too. So we want to make sure that they're well taken care of, and also pray for the conversion of the other side. Obviously, we care about their souls as well. And so that's always important. But what practically you all can do in terms of doctors and submitting something are helpful in this case, I think the number one thing is, regardless of how this turns out, even if we win, what I want to come back to the district court with is even more evidence of doctors, members of CMDA being harmed by this. Oh, yeah, because I think one of the questions will be like, well, the scope is you only had 7 declarations in support of this. Justice Gorsuch alluded to this. And, no, this is more widespread. We don't actually need to have, a plethora of doctors to win this case. But it would be helpful to have to show, like, I know you all have doctors in every state. To the degree we can talk about these, examples. And no, actually, I treated someone just recently this way. I treated a victim who got these drugs mailed from New York. That is helpful. So having these stories told and people willing to testify and through declarations or other means would be helpful. So I always say, come forward. I think when you build this case kind of behind the scenes, kind of obviously in secret and confidence when you're building it, you can't solicit that. Now that this is wide open, it's in front of the Supreme Court, it's easier to ask for this. So I think it'd be helpful for your members to continue to engage with you and share these examples with you. And then, we'll take it to the next level if that conversation makes sense.
Erik, since the sitting in the Supreme Court with a panel of doctors from the other organizations, leaders, and hearing justices and Aaron Hawley have a conversation back and forth, I know that the other physician heads of the organizations and I felt the same way, that the justices were asking questions and presuming the sorts of stress or distress that a physician in the emergency room dealing with a woman who's bleeding after taking Mifeprex, what their options are. And as I looked at the other physicians, we're kind of shaking our heads as the justices just don't understand the situations fully that we are put in as caregivers who love these women and want the best outcomes for them. And yet they're bleeding with a pregnancy. So, Jeff, as we finish up here, I want to ask you, help our listeners understand the distress that you would face going in and seeing a woman who's bleeding, who's taken Mifeprex, whose baby is, the heart is still beating. What are you facing?
Yeah, I think that's important for our listeners to understand. They may assume that mifepristone, works 100% of the time by killing the embryo. And then with the misoprostol will empty out the uterus. Well, that is not the case. In fact, it hasn't been studied well how often the baby does not die. But the fact that the FDA is even saying, as Erik alluded to, that most of these women can just go to the ER or they can go to their OBGYN or whoever if they have any complications, it is not at all unexpected that they may be further along, the baby may not be dead, and therefore they start bleeding because of the misoprostol, and that's causing uterine contractions, shearing away the placenta. And so our members are put in a position where they are in essence doing an abortion. Even though they're pro-life, they have sworn before the Lord never to do that. They have to do that in order to save the woman's life. Now, of course, they're going to take care of that woman, but does that harm them conscience-wise to get out pieces of a baby that's still alive? Absolutely it does. And for us not to recognize it is critical.
And the justices suggested, at least one of them suggested, that maybe we could call a timeout and call administration and say, I need someone else to come help this woman. Is that practical?
Well, as I sat in the room listening to that, I was shaking my head. They have no idea. You have a woman with an ectopic pregnancy, or in this particular case where a woman is bleeding, you don't have in place these conscience protections that the hospital can just simply call up and get somebody else who isn't on call. Especially in a rural area where I practiced, I was having to be the one to deal with whatever kind of issue came into our ER. No one else was there to help them.
Erik, any comments as you've listened to us talk here?
Yeah, I just want to echo one thing as well. One thing we did, the conscious harm is so clear to us, and we've had briefs from our friends too. We had a big coalition of amicus briefs in support of this case. And a lot of them talked about this too. But the bars for standing is so low, actually, in many respects. And I want to highlight this because I talk about this a lot, and just for people to understand, Because I think the justices were focused like, what if we just grant you these conscious exceptions? The federal laws protect you and you can call a timeout. Well, sure, you can't call a timeout, but there's other arguments. I noted this, and that is, I always think go back to my environmental days, and I think it's so important to understand, like, where I used to represent industries where they wanted a pipeline built, let's say, and I'm going to not name any organization, but there's an environmental organization out there with a member who says, I want to go visit this endangered species. By virtue of building this pipeline, I won't be able to travel to this federal land, and potentially I may not be able to see this endangered species. And that breaks my heart. That causes me distress myself. And that is enough to bring down an entire federal program, a pipeline approval that will never get built. And so we've also talked about the emotional harm. Even if, to the degree this grieves our doctors, it breaks their heart for the women, for the unborn baby, to having to be kind of conscripted into this service where their OBs are here to really bring life into this world, not to be a part of the process that electively brings it to an end. All that is to say is that we clearly have a harm here. And Judge Ho at the Fifth Circuit Court of Appeals noted that. He's like, if those environmental members, one person, all it takes is to bring down a federal program, we have a plethora of doctors over here who have suffered even more egregious, tangible, palatable harm here on an emotional level as well. And so clearly we have standing. And Justice Gorsuch alluded to this. He told the Solicitor General of the United States, you're going to have a problem addressing that. So he didn't expand on it more, but if that body of law is going to continue, which has been allowed to, environmentalists have been bringing these type of cases for decades, then clearly we have standing. So they're going to have to do jujitsu, not to find that we have a conscience injury, an emotional injury, a diversion of resources injury, and organizational injury, because there's longstanding Supreme Court precedent supporting all of this. So I reiterate that because it's going to be an interesting decision come June or early July, how they're going to square this with the prior cases that they've found standing for.
And wouldn't you love to be a fly on the wall in chamber listening to their discussion on those very issues? Well, Erik Baptist, thank you for being our guest today. And please pass our appreciation to Kelly Fedoruk, to your CEO, Kristen Wagner, and so many others who provided us with security on that day and took wonderful care of us. Jeff, I don't know how many cases so far, even during your tenure, we've been involved with ADF, but there are many.
Several. And so, Erik, I just want to tell you thank you again for your work and how God has prepared you for this case. I just think that's absolutely fascinating, that your background with the EPA and how he just brought you to ADF at just this time for a case just like this. So I'm so thankful for you and all of ADF staff and the attorneys. What a blessing.
Well, I'm grateful for the CMDA and all your members and our great partnership and the many cases that we work together on, because it's so important. And as you know, the practice of medicine is personal to me. I grew up with a father who's dedicated, to the pro-life movement and also taking care of patients who really showed a dedication, because that's what you do. You do it for your patients. And really to see that day in and day out, and now to be able to serve doctors such as himself is a great honor.
If you're listening today to the program, Erik challenged us to pray. So please pray for the justices as they're deliberating on this case. God bless you, Erik.
God bless you all as well. Thank you.
Well, March 26th at the U.S. Supreme Court truly was an historic day for healthcare conscience freedoms. And both Dr. Barrows and I are so thankful to Erik and the rest of the incredible ADF team for all their hard work on this case. While Dr. Barrows and I were privileged to be inside the court listening to the oral argument, dozens of healthcare professionals and students from CMDA, as well as the American Association of Pro-Life OBGYNs and the Catholic Medical Association, as well as other like-minded pro-life organizations, were outside the Supreme Court holding a rally on the steps of the court. What an incredible display of unity of purpose as we stood together to make our voices heard and protect women's health. That women's health, it matters. If you'd like to watch a video to get a closer look at the day's events outside the court, be sure to click the link we included in our show notes today. Both Jeff and I want you to know how grateful we are for our CMDA members and champions who committed to pray for us as well as our lawyers with ADF, and especially Aaron Hawley, who made the oral argument on behalf of the Alliance for Hippocratic Medicine. In fact, more than 500 CMDA members set aside March 26th as a day of prayer in petitioning our God to move mightily and miraculously to protect women's health. As God's word says in 1 John chapter 5, verses 14 and 15, this is the confidence that we have in approaching God, that if we ask anything according to his will, he hears us. And if we know that he hears us, whatever we ask, we know that we have what we asked of him. In fact, just 2 hours before she argued before the court, I was able to share with attorney Aaron Hawley that more than 500 CMDA folks, like some of you, were actively praying for her. She gave me a big smile and told me how much of an encouragement such prayer support was to her. So straight from our attorney's mouth, your prayers made a difference, CMDA. So what happens next? Like we just discussed with Erik, we urge you, please keep praying as we await a ruling in this case. I have confidence that God has been hearing our prayers on this issue, and he will continue to listen as we turn to him, friends, in prayer. In the meantime, CMDA needs your help. The federal case is just part of our work and advocacy here at CMDA. Will you prayerfully consider getting involved in CMDA's advocacy efforts in your individual state? To get involved, you can visit cmda.org/advocacy. Through this case and our ongoing advocacy efforts, we are on the front lines as we work to protect the vulnerable. We depend on strong financial as well as prayer support from partners and friends like you to serve as a Christian voice to the government and to the media, to the church, and to the general public. Will you give a generous, much-needed gift to protect life at all ages? Please take a moment to pray about what God might have you give, and then make your gift today by going to cmda.org/give. Thank you, friends, for your prayers and for your financial support. May God give each of us renewed courage and confidence as we speak his truth about the dignity of every single person made in his image in the public square.
Here at CMDA, we are often called on by the national media to provide expert media interviews and perspectives on topics like abortion, transgender, assisted suicide, and more. From congressional testimony to network television, God continues to open doors for CMDA to amplify the voice of Christian healthcare professionals on the critical life issues of our day. And we need more experts just like you to help. Will you consider joining us at this year's Voice of CMDA media training to learn how you can become a media expert in your field? This 2-day conference on August 9th and 10th, 2024 will teach you how to be a CMDA media representative. We will explore how advocacy and media work hand in hand together to prepare you to use your media skills and testify in your state legislature. For more information and to register, visit cmda.org/events.
Well, next Thursday, I want you to be sure to listen in as Dr. Barrows and I are joined by Dr. David Hager. He's a CMDA member from Kentucky who is, like Jeff, an OBGYN, as well as a nationally known speaker, author, and researcher. He's recently released a new book entitled On the Way, Ministering in the Moment. And he joined us on the podcast to talk more about his recent book. As we close out today's episode, I want to share a verse from Hebrews chapter 4 that says, "So let us come boldly to the throne of our gracious God." There we will receive His mercy, and we will find grace to help us when we need it most. Over the next several weeks, as we await the court's decision, I ask you to continue joining us in praying boldly as we believe in God's power to move in the hearts and minds of these 9 justices. As we discussed near the end of our interview, let's pray for the justices that truth will ultimately prevail. Let's pray for Erik and the other lawyers at ADF, for the other national medical associations who are involved, and for the women who are being impacted by the dangers of the drug Mifeprex. Let's also pray for the continued impact of CMDA's advocacy ministry. We here in Bristol have no doubt that the Lord will hear the prayers of the righteous, and through our prayers, as well as our continued engagement in this case, we will be bringing the hope and healing of Jesus Christ to our world, friends. That's what matters to CMDA, and CMDA matters more than ever. God bless you, and we'll see you next week, Lord willing.
Thanks for listening to CMDA Matters. If you would like to suggest a future guest or share a comment with us, please email cmdamatters@cmda.org. And if you like the podcast, be sure to give us a 5-star rating and share it on your favorite social media platform. This podcast has been a production of Christian Medical and Dental Associations. The opinions expressed by guests on this podcast are not necessarily endorsed by Christian Medical and Dental Associations. CMDA is a nonpartisan organization that does not endorse political parties or candidates for public office. The views expressed on this podcast reflect judgments regarding principles and values held by CMDA and its members, and are not intended to imply endorsement of any political party or candidate.